Not late, Matt, because we're going to be late.
What time? You said 5:30.
We have to go to Winter Park. Okay.
Hey there, it's Matthew Hill and Carol Ponton.
Hey, you can hear us.
Less technical issues hopefully this week. Here to talk about VA benefits and hopefully have some. Oh wow, I got feedback. So let me just get rid of this. Okay, sorry about that. So looking to answer some more questions about VA benefits and hopefully help you all on your claims and on your way. So let's see. We've got a lot of hellos and
hello.
Blowtorch, come on sound. We did it this time. We didn't do it this time.
Efrain did it.
Here. Yeah, this
We're
is the
incompetent.
office view. That is. We usually honestly work out of our houses, but today we thought we'd come into the office and try a little bit different view here. Okay, so we don't have any questions. You got anything burning?
No, just how slow the BVA is.
Yeah, people ask us that every week, and unfortunately, it just seems to be slower.
And slower and slower. And you know, one of the problems is I think a lot of these people are government workers and they have a use or lose, so they have to take their days off. And so when you get near the end of the year, you get a lot of people that are out.
It's gone.
It's gone. So this is a slow time.
Yeah, and they just finished their fiscal year this last year, and so I think they had numbers to make, and then once they made that, it's probably we've just been seeing a lot of checking out. Yeah. So, okay, we got a couple questions here. Linda Labe, we have a question: can VA rate 0 for chronic fatigue syndrome?
Yes, and they do.
She never even lets me finish the question. I checked e-benefits and it looked like they rated me at 0. So
I'm quick.
you are quick.
I'm
Okay.
not techie,
Yes,
but I'm quick.
They do, and if you have problems with chronic fatigue syndrome, it's impeding your ability just to maintain your daily life. You need to appeal that and look to see if you can get a higher rating of 30%. Is it 10, 30, 60, I think is the rating.
If you're being treated by a doctor, you probably want to get those medical records in there to show the constant fatigue, all the problems that you have, and make sure when you go to the doctor you're complaining about those so they're written down there. And that's how they rate you, based on what you're complaining about. This is something they can't really test, like how far you can bend
Right.
or what your temperature is. So really they're getting all of their information from you. So I suggest that you look at the chronic fatigue regulations and make sure if you have these problems that you're telling them all about it, okay?
Okay, let's see, I think I skipped a few here. I had my hearing back in May. Now my lawyer won't communicate with me. I want to replace him. How should I go about that? And do I owe him anything? Tom, that's tough. If you had your hearing back in May, first of all, he has no control, he or she, has no control as your attorney to speed that up. You would think that, when I first started doing this and we had a hearing, I'd think, oh, great, we just had our hearing, we've got all the evidence in, the judge knows what they need to do, and then it would sit for months, for years. So, I don't know what the attorney did here, but I will say that they have no control over this, and it's absolutely maddening because you'd think if the judge just spoke to you, it would be most efficient that they actually wrote out the decision at that point.
Yes,
But they don't.
it can be years, I hate to tell you.
Yeah, efficiency is not allowed in the VA system.
And I have had so many people say, we don't do hearings. I don't think it helps you at all. But I've had so many people say, well, the judge said they'd get that decision right out, and that was a year ago. So I don't know why, it doesn't make any sense to me, but that is what we see. So you're a lawyer just by not making it move. Now, if you have a basis for moving it, if you're 75 or older, or if you are homeless, or if you have lights or utilities cut off, or threatened to cut off, or eviction, or things like that, then the BVA will move your case. So you need to make sure that even if the lawyer doesn't get back to you, you can write to the BVA and tell them what's going on. But other than that, they are not moving anything. And unfortunately, believe me, we have tried everything.
Right. And as far as you getting out of the contract and owing them, you just need to see what the contract says, what you all had agreed upon. If there is, some kind of fee that you have to pay for, I guess, him or for any medical experts that were, produce reports. But you are hopefully towards the end of this. So it being towards the end, hopefully, you're going to get there. So shaking things up, if you don't have to, I wouldn't. But, I don't know all the circumstances. Tom Anita Wilson, I'm still in the holding pattern. I see you. Please hold tight. I know that's frustrating. All right, let's see where else we have. John Price, for psoriasis claim, it says continual use of steroids for a year is a 60%. Would that include my eyes? I have I'm going to mess this one up. Uveitis due to psoriatic arthritis and psoriasis. Yes, if he's
I would think so.
I mean, it's
Yeah.
not. You don't. If you're using steroid cream for that, then yes, it should be a 60%. They screw that up like it's their job, though. Unfortunately, that is not one they get right all the time. All right, Luis, hello. Do you know if sleep apnea can be a Gulf War presumptive condition?
No, I don't think so.
No, it's not presumptive.
No.
But it definitely can be related to Gulf War. We see that a lot, but you still have to prove it through a non-presumptive way. Bruce Robinson, which is better? It's a file separate claim such as sleep apnea as second. Okay, hold on a second. Which is better to file, a separate claim such as sleep apnea or as secondary to PTSD?
File both. Oh, I'm sorry.
No. I'll say this. The thing about that is the VA wants you to think there's a difference, and there's not. You're trying to get service-connected compensation for sleep apnea, okay? Whether it's caused by directly something happened in service or secondary to your service-connected PTSD, that part doesn't matter. You don't have to put that on the initial pleading. You don't have to commit, is what I would say, to one angle or the other at the beginning, okay? So I would just say that you file for sleep apnea, you could mention in there, I have PTSD, it's service-connected, or on top of that, my bunkmates all said I snored or I'd stop breathing at night. You can put all that in there, but you just need to understand that you want service connection for sleep apnea, and the VA has a duty to assist you to get that right. So, Carol might actually literally put down both angles.
We disagree on some things. You may have caught that.
I need a power charger. Yeah.
So for me, the problem is I tried doing that, just sleep apnea, and then they would, the VA may or may not look at the PTSD aspect of it, and then I'd ask for a higher level review. I'd have to ask for a duty to assist. So we're different. I like to put all the bases that I think of so that the VA will have to examine them. When the CMP examiner goes in there, there should be asking, is sleep apnea from service? Is it from PTSD? And they should be answering all those questions. And for me, that moves it along a little faster if they actually do that. So we're different. He likes to do just a broad general, and I like to put as much specific down, so I make sure that they outline everything, they examine everything.
And again, I mean, it's a matter, to me,
Yeah.
I don't want them to buttonhole me, say, oh, this is specifically what you asked for, we're not going to consider secondary, or you asked for secondary, we're not going to ask for direct. So, we've been wounded by different shrapnel when it comes to VA screwing us over on claims like this. But, at the end, if you think it's either PTSD or direct, then do what Carol said, but put them in both. You just don't have to. All right, so...
You're grumpy today.
All right, Old Sergeant. Maybe you're grumpy too, Old Sergeant. CMP exams were submitted to the VA 30 days ago, but no action on my claim yet. Looks like there's a long backlog.
I was complaining about ones that were done in January to the VA last week. So unfortunately, 30 days, they're not even going to pay any attention to you.
Yeah.
Unless you've got a basis for moving it faster.
It's slow right now, that's for sure.
And by the way, the complaint, nobody has responded to it yet.
Let's see. Oops, where were we? Do you have a time frame for getting a C file? It depends if you have, getting access. I generally say 6 to 9 months unless there's a hiccup.
Yep.
Sometimes you're able to get access to your file online, what's called the e-folder. I, for one, do not love the e-folder because I never find it to be complete. I mean, it could be like a couple pages short, or it could be a couple 100 pages short.
And you never know for sure.
And the problem is, even if it's a couple pages short, there could be that one page that you needed to show that the VA messed up or show that it should go back farther. So, we use that in a pinch, but if you request a file, hopefully you'll get it.
They tell us that it's the whole file, but over and over again, we're finding, if we compare the e-folder with the C file when it comes in, that, like Matt said, there could be pages missing, and they could be important pages. I have found, I thought, oh my gosh, here's a great opening. They didn't they didn't send a copy to the 22A didn't go to the person that should have. If it was the American Legion, they sent it to the DAV. But then I get the C file and see there was another 22A for the DAV sent in there, and it wasn't in the E folder. So it can go both ways. You can think, so yes, that's the problem, not having the claim file. And for whatever reason, they're telling us that they're going to put everything online, and then they won't be sending C folders anymore.
They'll just give us the access, yeah?
Yeah, they'll just give us access to the online E folder. But that concerns me.
They're telling us.
They're telling us that. Yeah.
We have not seen that yet. All right, so I am charging. Thank you. Yes. Okay, so James Sellers. Let's see. I don't know if you answered my last question because of the sound, but my question is: can I claim degenerative joint disease and degenerative disc disease secondary to my lumbar spine strain?
Degenerative, so like arthritis in your spine? Yes, but that's only, well, it depends, but that's usually just a 10% rating, and it may not be that if you've been giving something for range of motion or other things.
He could claim, the degenerative disc disease or joint disease, which would be like a 10% rating per joint, and then degenerative disc disease, the range of motion on that, he could claim both of those, so he could be rated for both of those. So the orthopedic issues are kind of interesting in that a lot of joints can have multiple. The knee is the most extreme. You have multiple ratings for each. But if you have a joint, if you have what's it called, just degenerative disc disease, not if you have
arthritis,
right? Mm-hmm. So each arthritic, what is it? Joint. Yeah, you can get 10% for.
Well, not each separate one. Sometimes they call them major.
Yeah, right.
It's pretty complicated. But he brought up something interesting, and that's the knee. Almost every abnormal range of motion for the knee. So you can have, like they have forward flexion, or they may have, rotation. For the knee, each one of those you can actually get a rating for. Where the back, back doesn't work that way. The back, they give you kind of a combined or whichever is worse. But the knee, you can get separate ratings for each one of those abnormal range of motions. So make sure you look at that. It's a really good way to get a huge rating for your knee.
Does total disability due to unemployability affect Social Security pay?
No. If you're getting regular Social Security disability, in other words, you worked, paid into the system, and you're paid regular Social Security, you're entitled to both.
Or retirement,
Or retirement. The thing that confuses people is there's a supplemental security income, and that's for people who are not insured under the system and have no other source of income up to around $700 a month. So it's sort of like the VA. The VA has a system that's called VA pension, and that's around $1,200 or $1,300 a month. And those are the two things that are based on other income. Regular Social Security disability and VA service-connected disabilities they're not related to that. You get both. And you should file right away. For Social Security disability, the key, you have to show two things. One, you're totally disabled, but the other is that you have worked and paid Social Security taxes for 5 out of the last 10 years. So if you're sitting around waiting to get your VA benefits and then you're going back, remember those 5 years are going by, and the judges they feel like, well, if you'd been disabled, you'd have been in here applying. So now you're coming here 5 years later, you're not insured anymore. So go in right away and file for Social Security disability as soon as you know you can't work.
Okay, Matt B., diagnosed with chronic fatigue syndrome and fibromyalgia at VA. Can they claim pyramiding when they are presumptive? They have similar symptoms. I'm afraid they'll only rate the fibro because the max is 40%. They can claim pyramiding if the similar symptoms are the highest rating. Okay, so whatever you're showing, 40% for fibro, if that's the same rating for chronic fatigue for those issues.
So what are your complaints for fibro? Do you have chronic fatigue, or is it joint pain? Is it headaches, fevers? So those are separate from chronic fatigue symptoms. So you're not going to get, if your main fibromyalgia problem is chronic fatigue, then yes, you have a problem, but probably you shouldn't, because they're two separate things.
This is where you want to look up in the rating schedule of each of those, figure out what each percentage is looking to find on you as far as the problems you're having. And you want to see what's the max you can find for this one and the max you can find for that one that do not overlay.
But remember, these two diseases, your rating it should come exactly from what you're telling your doctor and the VA, because you know what your symptoms are. It's not something like how far is your range of motion for your back that they can determine. This is solely coming from you. So you need to know what the VA guidelines are and make sure any of those problems you have are well documented in your medical records and when you go to your CMP examiner. And this is where you want to get a copy of your CMP exam and make sure that they wrote down what you said, because unfortunately, we often see where examiners somehow fail to put down what you said. And if they do, you want to take this opportunity to say, this is what I told her and this is what's there. I want another exam because clearly this examination the examiner was incompetent, or I don't know what was going on, but this is not what I told the examiner. That's really important.
Okay, Vincent, when obesity is used as an intermediate to service connect, what happens when they lose weight in the future? It's a fascinating question, but let's say you have back disability and it's caused you to gain a lot of weight, and then because you were sedentary and just not exercising at all, you developed diabetes. Well, if it turns around, you lose 60 pounds, 100 pounds, or whatever, and you're no longer obese, but you still have the diabetes,
right,
it's still because of the back problem. So,
right,
so the obesity kind of is a bridge that even once you get there on the other side, even if it crumbles, it doesn't matter. That other piece is service connected. But that is a really fascinating question, Vincent. So please do keep in shape if you can. Don't worry about your service connected benefits on that. Ralph Andrews, I injured my knees while in service but can't get approved. I've been to PT therapy 3 times and denied the shots 3 times. How can I do it to prove how can I do it to prove that they're service connected? So basically, what can he do to show it's service connected? Okay, so clearly you have a problem now with your knees. I'm assuming you have a diagnosis. That's step 1. Step 2 is to show something happened in service. Okay, something can be anything. You could blow your knee out playing football with the boys after coming back. You could get an accident on a motorcycle, hurt your knee. You could be carrying too much for too long as far as hiking up and down hills and just having too much on your back. It doesn't matter what it is, but what matters is that it's noted in service. Now, the VA wants it to be noted in your service medical records or in your service records. They want to say, I saw it right there, fine, I'll concede it. But that's not true. If you have a buddy who saw you limping around in service, or saw you get hit, or saw your knee get taken out, and you didn't go get medical treatment, that's pretty common. Get that guy to give you a statement, okay? But you need something that shows you this is a problem. If you're a paratrooper and you have a badge in there showing how many times you jumped, that actually is something you could take to an orthopedic, and they would say, okay, this is this trauma, back and forth, consistent trauma that you've had could cause these problems, okay? But you got to have something that did happen in service and that you can, in addition to your story, show through records or other statements from people or something like that.
Well, so what you want a statement from someone who knew you before service and after, saying you had no problems before. This is what I noted after. I noted that you limped. And remember, there needs to be a consistency. So you want to make sure that they know it's not that you had a problem in service and then it stopped. This is something that has continued on. Maybe I've had people say, we used to play tag football, we used to play basketball, and when he got out of the service, he couldn't play any of those because of the knee pain. Or if he did, he'd be limping around. So you want to make sure both you say and your witness, no problems before, this is what I observed afterwards, and it has continued up to date. And if you're a paratrooper, it's much easier because the military actually did studies that show that it is likely that all these jumps would injure your knees and your back. So if you can find that online, that's always something good to submit, because somehow they forget that that was their own finding. A lot of our doctors will use that as a basis for proof that you should be service connected.
Okay. Scott, a question I have. I'm disabled, unable to work, and have had it that way for 15 years. I do get unemployment benefits, but I'm still not 100% from the VA, and the state is saying I can't get SSD. Well,
if you can't work, I don't know why the state doesn't have any. Oh, is there something else on it?
I'm just wondering if he ran out of room and. No, I don't see anything. Scott, if there was a question with that or something you wanted us to put together, let me know. But we're not just going to speculate.
The state is not the one that decides whether or not you get Social Security disability. It's the federal government. So you have to file a claim for Social Security disability benefits with the federal government. The state has nothing to do with that.
Okay, Antonio, how do you claim chronic back pain that was created during my service 87 through 91? U.S. Navy. I was also exposed to white phosphorus as a 5-inch gun loader. So this is just what we talked about before. You got to show that something happened, and then you got to back it up, if you will. It's called corroboration, meaning you have somebody else talk about it, you have records from service, but something that happened to you that caused the pain, and then you have evidence backing up what you're saying. That's what it comes down to.
And remember, there's something the VA doesn't tell you. If you had an injury during combat, they have to take your word for it. The rest of the time when you're in the service, they don't take your word for anything. But during combat, there's a specific case that says if you were in combat and your helicopter crashed and you injured your back, or if you were in combat and you tripped over a log and injured your knee, they have to take that as true. They cannot say that didn't happen. Now, you're probably not going to get approved at the regional office for that, but you will at the board if you note that it was combat. I would also back it up with statements before and after, but that's law is very strong.
All right, John, I'm filing an increased rating, which I believe will go to at least 70%. I'm also planning to file Tdiu. Can I file for Tdiu before I get the increased rating, or must I wait?
Mm-hmm.
I file it right away.
Yeah. Remember, there's almost no reason not to file everything right away.
Duwatney 16, 100%. All right, I got to go back to that. So we've always filed everything right away because we want to try to push it through right away. The one thing that I've seen happen lately that has given me pause is that somehow the denial for the, if you're trying to get a higher rating for the underlying disability, you file for the Tdiu. Somehow, every once in a while, that Tdiu will get in front of, farther down the line for appealing than the underlying one. And then we've had them get all the way to the board, and the board will say, well, we're denying this, even though it's related to the underlying claim, and that underlying claim is still pending. They say, oh, well, we're denying this because you're not 70% or whatever right now. So then you have to go all the way back through.
But you still get that date.
You do, but still, I just to let you know, I've given this a lot more thought now than before. I just always filed it. Now I really want to look at it and see, should I wait a little bit?
Okay, so before it was under the legacy system, and there when you went to the board, they correctly would send the unemployability back and say, now that the rating is higher, determine whether they're entitled to unemployability. Well, under this new AMA system, that's where we're running into. At the time you were denied, you didn't have a high enough rating to be considered for unemployability. So for unemployability, you have to have a 60% rating for one thing or combined rating of 70%. So that's what the board is looking for. So like Matt, what I've started doing is I file the unemployability. If it's denied initially and at the higher level review, and I still don't have that rating of 60% or 70%, then I just go back and file a supplemental claim, and I circle there at the regional office till I have the rating that I need, and then go to the board if I don't get that approved. So, that's what you need to watch. Don't send it to the board if at that time you don't have a high enough rating.
It's maddening right now as far as how you have to, the complaint before was how complicated things were. It's hard to get to appeals all the way up to the board, but now it's just the choo-choo train goes around here, and if you go up here, you might have gone too soon, or you might have gone on the wrong lane. It's pretty frustrating.
And reasonably, you would say the board should say, this is connected to claims that haven't reached us yet, so we're going to remand it and put them together. For whatever reason, they don't do that; they just deny them. So make sure you have that 60% for one thing and 70% for combined. And remember, the 60% for one thing can be, say you have a back problem that's caused radiculopathy and urinary problems. That's all combined because it's really one thing. Or you have diabetes, so you have 20% because you take an oral medication, but you also have peripheral neuropathy, urinary problems, or eye problems, and they're combined to 60% or more. That's the one thing that you need. So it doesn't have to be, the combined can be easier than you think, okay?
Okay, I've got 100% P&T. I put in for an 1151 for kidney failure, but the VA denied my claim, saying it's not service-connected, which I know it's not. How do I appeal and get it reviewed for an 1151 judgment? So the 1151 is basically just saying that it's kind of this parallel universe. Instead of something being service-connected, it's related to fault on behalf of the VA, usually VA medical care. And so if you're saying that they caused an issue with your kidney, it's the same process. Even though it's an 1151 claim, it's, you file a supplemental claim or the original claim, it's denied, then you either go to higher level review, you have a supplemental, new claim with new evidence, or you go to the board. So the process is exactly the same, even though it's a different theory of entitlement, if you will.
So the process is the same, but the proof is different. So the proof, in this case, you have to show that malpractice was committed, negligence was committed by the VA. In other words, that this wasn't a foreseeable outcome. This was something that shouldn't have happened. So the proof is different. For regular disability, you just showed that it should be service-connected because it happened in service or was caused by something that happened in service. You're on a whole different plane here because you're more into the medical malpractice. You also ought to see if kidney failure could be due to something that you are service-connected for, because remember, hypertension, diabetes, there are a whole bunch of things that can cause, sleep apnea can cause hypertension, which can cause kidney failure. Diabetes can cause kidney failure. So I would go about it two ways, because 1151 is a lot harder because most doctors don't want to say somebody else committed malpractice. They just don't want to do it. But if they can say this is a normal, foreseeable consequence of having hypertension, you've got what you're asking for, and it's much easier. So see if there's another way to service-connect it other than 1151 as well.
Okay, and I think Ray, you are answering a question that we had before. Ray Adkins, there he is, okay. Need help refiling, already at 30%. And what did he say here? 30% getting more evidence for higher disability. Need help having trouble continuing working. So file that supplemental claim. If you're having trouble working and basically you stop being able to work, then I would I'd file for unemployability on top of that if that's what's keeping you from working, or that's what's substantially keeping you from working.
But remember, you don't want to reopen a claim because there's really no such thing as that. You want to, if you have 30% and it hasn't been a year, you want to appeal that for a higher rating. So always try to keep the appeal going, because then you have an earlier effective date. They won't give you the benefit as of the day you filed the new claim. So remember, if it's 30% and you thought it should be higher, that's an appeal. That's not going back and filing. You can file a supplemental claim and say, this, I don't think the 30% was correct, and here's the evidence for it. But always try to make it an appeal rather than a new claim on that.
Yeah. Benny, as far as your question, I think Stacy will reach out to you today. I think we actually did get a decision in. I haven't had a chance to read it, but hopefully she'll reach out and we'll have a chance to talk soon. Mr. B, CMP exam for hands, feet, and knees with a VA hospital, not contractors. Is that a good thing? There's no rhyme or reason. You never know who's competent and who's not. And that's very unusual. I mean, I have seen one VA exam in the last year. Almost all of them have been. It's rare.
That's
rare.
rare.
We'll give you that. It's rare. But
I don't know why they're doing it. Yeah, who knows?
Yeah.
But remember, it should be someone who's competent to do that. It should be like an orthopedic or podiatrist on the feet. It shouldn't be a GYN or a general practitioner, I wouldn't think.
Okay, so Rabid Squirrel, been waiting 2.5 years for my PTSD claim to go through. I know that's awful. It's waiting, and it's so frustrating. That's the name of their game still. I mean, it's like if they can outweight you and you go away, they keep your money. But that's kind of what they do, and it's you just gotta force yourself to grin and bear it and keep fighting.
Say you're not going to let them beat you. There's no way.
Mr. B, my military records are not in my C file. So this is an interesting, frankly, it's something I don't see that often, but sometimes so when the VA is putting together your C file for the first time, the manner, of course, is for them to reach out to the National Archives and ask for both your service records, your service jacket, and your service medical record jacket. And typically they get those and they associate it the first time you have a claim, and they put that in a file. So the fact that they didn't put that in there is pretty interesting. It's also interesting if you filed a claim before, if this is not your original claim. We see this a lot with PTSD, where if you filed, let's say 10 years ago, and then you file now and they're just now putting all those records in. Well, if you win that claim, second claim on the same issue, PTSD now, you could actually get your case back all the way to them, because they should have put those files in your records to begin with, because they're relevant to what where you were, what you went through, those kind of things. So I would ask for that if that's what you're saying, Mr. B, as far as getting them. And you could write the VA, or you could write the National Archives and say, can I get a copy of these?
I would say that for the first 25 years that I did this, Matt, they did not put the military records in there. That they only put if they had them, the service treatment records. And it's only really been in the last few years that I have seen they've started on their own putting the military records in there. So look through that C file and look and see what was there when they did your first claim.
Okay. Glenn, can sleep apnea be secondary to service-connected hypertension, since sleep apnea can aggravate the hypertension?
I've never researched it that way.
Yeah, I don't know.
I'm sorry, I don't know that. I'll have to look that up.
Be a non-service connected issue aggravating a service connected. Yeah, I don't know. But if you've got the research and it shows that you got to show the first part, that the hypertension either caused or aggravated the sleep apnea. But okay, let's see. Bill McGrath, sleep apnea secondary to PTSD is approved. Degenerative arthritis, cervical spine, and lower neuropathy denied second time. I have multiple back injuries in service, but I'm 63. VA said age-related.
There's no such thing as age-related.
Crap. Yeah.
If you ask most orthopedic surgeons, they'll tell you there's not. I mean, there's some people that are 80 years old and have no arthritis and are in great shape. So.
Yeah, Bill, I'm excited for you. You got that sleep apnea claim through. I know you've been fighting on that. That's great, but I wouldn't settle there. I agree with Carol. You need to keep the appeal going.
Right.
Hopefully get a doctor who can look at it and say, what Carol said, well, no, this is not how it works. Okay, Bruce Robinson, I was recently diagnosed with fibromyalgia and have been told it came from PTSD, but it's also presumptive for Gulf War.
Yeah.
So you got two angles there, but the easier one is the presumptive.
Yeah, always go with the presumptive if you can. Because then you're not fighting about service connected, you're just fighting about your rating.
Pablo Cardone's VA sent a letter of precaution, aka from now on I will have a police escort. Is this good evidence for pushing my 100% PTSD?
Yes.
Yeah.
Yes, definitely. You need to send a copy of that and say, PTSD has driven me to the point of whatever's going on. And for instance, here's a letter that the VA requires that I have someone accompany me whenever I come into the VA.
Yeah. And
ask for expedite due to my mental condition.
Couldn't agree more. Practitioner, you're recommended not to file a new claim and instead add to my existing evidence. Help me get 100% P&T. Thanks so much for your help. Didn't see an option to super chat. Is it date me and Sarah Moore, or me and Carol Moore, that I don't know what a super chat is.
Yes.
We're just glad that you can hear us for once. We're glad that's
yeah.
Super chat is when they can pay to chat, and it's like a spotlight on it. We don't have that.
We don't have that.
We don't have it turned on apparently, but what we are excited about is that it worked for you, and you're doing well, and you got the 100% you deserve. So we're glad we could be some small part of that.
Yeah, basically, she's asking is there a way to give you something?
Oh, okay. Patrick K. What does it mean during HLR? It now says VA is correcting an error. You explain it, or you want me to?
Go ahead.
So HLR. So the higher level review, most often what they're doing, they look at the exact same evidence. They look to see did the lower adjudicator make a right decision on that evidence. And sometimes what they'll find is that the adjudicator failed what's called the duty to assist, meaning they didn't either get an exam, they didn't get records, they didn't they didn't get medical records, Social Security records, work records, anything like that. So they send
Or it was a PTSD claim, or it was a sleep apnea claim, and they looked at it being service as opposed to looking at it being
Secondary.
from PTSD or
Yeah.
secondary. So secondary is a big duty to assist area.
Yeah, how it should be related. So they're basically saying you got to redo it. And is it a good thing or a bad thing? I mean, your claim
It's
still
a
being
good
considered.
thing
Yeah.
because they're taking, it used to be before this new system, you got a decision and you filed an NOD, period. And we love that because then the people that were seasoned, the people who really knew what the law were, who felt confident in awarding benefits would look at it and we would get really good decisions. That's gone. The thing we have now, if you're denied and you file the next level, which is higher level review, we are finding that you can hope for an earlier effective date or they will find a duty to assist. So whatever restrictions they're putting on these people, they must be incredibly severe. Because before, you could have the initial level saying you shouldn't be service-connected for PTSD, et cetera, and this one, using the same evidence, could say, no, I find you can be service-connected for PTSD. Somehow all of that is gone. We never see that anymore. So you have a very limited thing that you can expect from the higher level review. Duty to assist, so that's that person's way of getting you a whole new medical exam opinion to see if you can get somebody to say, yes, you should have these benefits. Or you can talk to them about an earlier effective date. Other than that, I would not expect anything. It's not going to happen. If it does, great, but I'm telling you, it's incredibly rare.
Okay. Let's see. William Curry, part of the claim was remanded. Other claims are still at the BVA. How long before can I expect a response? Did this one come in before? Part of the claim was remanded. I don't see this being an add-on question.
I guess my first question was, were all of these, remember it used to be that if you had issues under the old system, they were all together. There was just one case. But under the new system, they can make different decisions on erectile dysfunction or PTSD or whatever, and as they go up to if they're actually different decisions, when they go to the board, they're different decisions. And so even though they may have acted on the PTSD, that doesn't mean that the erectile dysfunction should be acted on because somebody else may have that. These cases aren't joined together unless they were joined together when they went up there initially. So I'm not sure if you're saying this case had all of these issues, one case, and the judge only acted on part of them. I don't see that. Usually they act on everything they have.
Yeah.
So it may be that somebody else has that case and therefore there's no way to know how long before they act on it. It depends on the date that it was filed, the judge it was given to.
Okay, John Price, another law firm, is claiming you can service connect obesity. Is that true? Veterans Law Blog was a source.
Technically, yes. Do we see it?
No.
I've never seen it granted. And I remember talking to the adjudicators. The most favorable adjudicators at the VA hate that. And they say, I would never grant for that. So yes, that's what the law book says. Have I ever seen it? No. Has Brian's never seen it?
Yeah, I mean, so that's Chris Attick's blog, and Chris was actually he fought a couple cases to get that through up at the Veterans Court, I think even the Federal Circuit.
But that's
his
at the
law
court.
blog, by the way, is great if you're looking for
he's excellent.
Something to read in addition to us. I'd highly recommend it. So even if you get obesity service connected, there still has to be something to rate. Okay, so if you're just you're just overweight, but it doesn't impede you going about your day or impede you from working, you get a 0% rating. But if we go back to that example we were talking about earlier, where you have diabetes because you become so obese and are so sedentary, the diabetes would be service connected, and there's ratings for that. So to me, I always like to focus on the service connected compensation and what do you have that's compensable? What should they be rating? And that's where I'd look on this, because it's amalgamous. Like you can't really tell. Yeah, your service connected for obesity. I mean, I think if and when we do see that, it's going to be a 0%. I guarantee you.
Yeah.
So you got to figure out what has the obesity caused: hypertension, diabetes, whatever. So look for the second level issues that are going on.
But if whatever you really have a problem with, if you can find another way to argue for that to be service connected, I do it, because I'm telling you, even though the courts do one thing, the regional office does a totally different thing. And what you want to do is you want to figure out, what can I get approved through them? What way is
the
more
fastest?
the fastest, and what way is more favorable? When you go to the court, you're talking 4 or 5 years, and then they send it back down, and you're going to get 0%. So figure out what you can do that will actually benefit you.
So I will say Chris Attic is a very good friend of mine, and he and I are very different in the laws we practice. He makes the law better overall for everybody by winning these cases up at the court. I just work on one claim at a time, trying to get benefits as fast as I can. So I don't really care about citations to law. I don't care about it looking good. I care about just getting benefits, and it's kind of like Carol and I are minors, and he's doing good things that help all of us.
He's doing great things at the court.
They don't quite understand it, honestly, at the regional office, what he's doing. So
well, it's not that they don't understand it. I just think
they hate it.
I think they make their own rules, and if you're not within those rules, because I've had a number of adjusters tell me, look, I know that the board may give you this, but I'm not allowed to. Like sleep apnea. Sleep apnea secondary to PTSD, I think I've seen 1 or 2 awarded at the regional office, and all the rest come from the board. And they'll tell me, I have a list of things I can and cannot do. If I try to approve this, my supervisor's going to say, no, deny it.
You just called them adjusters.
Well, they are. Advocates, whatever.
All right, Jose M. Hello, what is the age limit for dependents or when they age out? I'm 90% service connected. Do they have to be enrolled in school?
Depends on their age.
So if they're when they're born up until 18, they're in. After that, if they're in full-time, I believe, college, then they also are covered there.
Well, no.
Not full-time?
I don't think they're covered unless you're permanent and total. I think that they get benefits until they graduate from high school, and then I think that
because you're permanent total.
You have to be permanent and total, and then they pay for college through
See,
26.
I was talking about 2 different things.
Oh.
There's the dependent benefits,
right,
that are permanent total, but then there's just the additional $100 or whatever you get
a
month.
I don't think
we obviously don't. We're not the ones to answer this, but there's 2 things going on. If you're permanent total, they cover everything in terms of dependents who are going to get a secondary education or college or whatever. But there's also the $100 or whatever it is, per person.
100 or 120. That I think only goes through 18 or when you get out of high school.
Okay.
I think.
We don't know that, so that's definitely something to ask somebody else.
We do the disability part.
Okay. Coopsting, I can't read this. I'm going to lighten my ear. Can I work with 100% disability for PTSD, not permanent and total? Yes.
Yes, you can, but they're going to evaluate anyway. If you're not permanent and total, they're going to come back. So they have put you on, I can tell you, a reminder date, and when that comes out, they're going to send you for a CMP exam. And if you're working, that's really going to be evidence toward the fact they don't think you're entitled to 100%. It is very hard to get a scheduler 100%. So if they've given you that, that means they think you can't work. And I'm telling you, I would be very shocked if you're actually working and you go back in for another exam and they continue the 100%.
M&M motives. I am abroad now. Never returned to the U.S. due to my mother's death, COVID-19, and travel restrictions. I have since been fired from my job in January. I am 90%. Want to file for Tdiu. I'm unemployable here. I believe that you can just upload directly the form, right? So that you just file. I don't know.
You can file online for that.
Or is that
what?
I'm just wondering, is that a 526?
That's a 526.
Okay. So yes, you can file online. And
VA form 21/526.
And they have.
And you attach the 8940, another VA 21/8940. So you're filing an application on the 526. There's actually a little check mark to say, are you filing for unemployability? And then you're also attaching to that the 8940 that talks about when you last worked, where you worked, and why you can't work.
No. C. Sparrow, if you have to wear hearing aids because of tinnitus, is that compensable? I worked in the engine room and have severe tinnitus.
They only give you 10% for tinnitus. That's as much as you can get, whether you work in a room like that or not. Now,
You can get
you can get
you
it,
can get
but
service connected, but it caps out at 10%, which is
unless it causes like a mental problem
Mm.
or something else, but that's the mental problem being rated, not the tinnitus rated higher.
Miles R. What happens when a VA doctor won't give you a nexus letter for sleep apnea to PTSD? Then what do I do? You need to find an expert on
Private doctor.
Private doctor, yeah.
The VA doctors are pretty much not. They will get in trouble if they are supposed to help you, but they don't. It's very rare to get doctors that will really help you from the VA because even though there's been rules that say they should help you, we're seeing that the facility where they work is telling them, no, you can't do that. So you're probably going to have to get a private doctor.
Is it a presumptive condition to have neck problems being in the Navy, working in small spaces, i.e. engine room engineering, and
No.
have 4 buddy statements?
So the presumptive means you don't have to prove that it's service connected. Okay, so no, that's not presumptive, but that doesn't mean that. I think with the buddy statements, I think that could help you a lot, and yes, you should be able to prove that with the doctor's nexus statement. But presumptive, remember, is something totally different.
Yeah, it doesn't mean you don't stop appealing. I
Right.
definitely would say that. All right, who else do we have here? Where did I go? All right, Carol gave me the kick under the table. I'm running out of time. So let's see if we can get some new faces in here. What happens next? I just came off active duty, claim pending. I was recently diagnosed with severe arthropy, which is debilitating. If my
Severe what?
I can't read it because the
Arthropathy?
arthropathy. Yeah, I'm sorry. It's got a bright
Is
light.
that in your knee or where is that?
My arthritis and my joints come back low percentage. Should I appeal immediately?
Absolutely.
Yes. Bad Yeti. I got service connected for sinusitis recently. Can I do a secondary claim for sleep apnea? Yes. Gene Seminole Ranger. Have an active claim filed September 23rd. VA asked for the 8940. I have been unable to work and was awarded Social Security disability and have civil service medical retirement. And I submitted all the evidence required. It's cliffhanger. Gene, you didn't give me the rest. File it, and you should. Well, my advice is file it and keep on fighting it because that it sounds like you got it all there. All right. Let's see. 11 Super Life. I was talking to my VSO about filing an increase for PTSD and for a new claim for migraines. I never told him to file. I was just talking about strategy. Now I have a letter saying I filed. What do I do? Well, if you don't feel that it's increased, you can write a letter saying to the VA, hey, I think this was filed a mistake. Please withdraw this claim immediately. Or you could just go through it. I mean, if it's a claim for increase and you don't feel like you're better or things are a little worse, I don't know that hurts you as long as you're honest and you go with that. Michael McDonald, VA website says the BVA docket date is August 2019. I have a docket date of July 18. Should my appeal have been seen since it's more than a year difference in time? I'm a legacy appeal. You need to write them a letter and say, this is my docket date.
I don't
What's
know where
going on?
Yeah, but I don't know where they're getting that from because I have 2014, 12, 15. They're all over the board on that.
I've heard that, but yeah, I'm with Carol on that. I'll get something that's just been sitting there. The ones that get remanded, I think, definitely get lost. But I would write them and say, what's going on here? This is over a year older.
But that's not accurate, let me tell you.
And it says, will the judge who remanded one of my claims back to the RO be the same judge for the other claims? If you had a hearing, yes. If you did not, no.
Well, you don't know. It could be, but it's not necessarily.
Right. Right. But you have a chance. I think you have a pretty good chance of it not being the same person.
With all the judges that they have.
Yeah. All right. Rob, Ohio. I'm 100% permanent total for mental health. What's your opinion on working? I don't understand how someone 100% permanent total work and others say it's a bad idea. I have no interest in working. Don't work. I mean, you don't have to. If you don't have to work, then don't work.
I mean, that's the whole point of giving you 100%, so you can just stay and take care of yourself rather than be subject to stresses that are not good for you.
All right, just kind of jumping down around or running out here. Can 100% be retro paid for prostate cancer Vietnam? Yes, if you get it back retro. Meaning you had an earlier claim and you're able to get that open. John Thompson, Tdiu claim, 70% PTSD. My original doctor retired and files were purged. Can I just use a vocational specialist for my claim? Yes. Let's see. Willie Marshall, recently awarded Tdiu sheltered work environment for PTSD, also had other claims brought me up to 90%. Currently getting 100% P&T and SMC. 3 claims differed. Should I withdraw those? I would withdraw any claim you have if you're 100% P&T unless one of those claims gets you to 100% by itself or unemployability by itself, and the other ones combine to 60%.
Well, I don't know what the claims are for, Matt. If it's erectile dysfunction, then that's an SMC that will pay him extra money. If it's aid and attendance, that will pay him extra money, and none of them have anything to do with his IU 100%. So I wouldn't withdraw him. So the problem is I don't really know what those 3 claims are and how they would affect the rating that you have.
Those are good points.
Thank you.
I don't like admitting
He
that
is
much.
so reluctant. What?
I don't like to admit that much. All right, Big Ant, hello. What is the VA law that states the VA cannot use a non-service connected claim reason to deny your current claim? Example, ED due to mental disorder denied due to diabetes. ED due to mental disorder denied due to diabetes. So basically saying that a non-service connected. So there is no law saying that. There is a law saying that under the unemployability realm, that even if something non-service connected would keep you from working, they can't consider that. They got to look at just the service-connected
Right.
issues. But as far as an issue being caused by a service-connected problem or a non-service-connected problem, they can do whatever they want on that.
And they do.
Yeah. Any factual, Chris W., any factual info linking PTSD secondary to sleep apnea? Yes. You just go, there's studies online you can find.
Lots of studies online. And you want to submit all of those. I'd submit them a couple at a time, and then if you have a contrary opinion from the VA, then submit some more of those. Because if you look at the opinion from the CMP doctor, they usually just say it's not service connected or it's not related, but they don't cite any studies.
All right, Chris. Oh, sorry, we said that. Mr. Silver, my friend did a claim with a consultant. Consultant is a dangerous word, I think. No, seriously, these people are sneaking into the system that charge 5 times whatever they got. Do you know about individuals like this, and what's your opinion? My opinion is, watch out. You want a VSO, you want an accredited agent, you want an attorney. You don't want somebody who you want. I guess the question I would ask is, are you accredited? All 3 of those individuals have to be accredited.
So what makes that consultant really an expert in that field? You have no idea, because they didn't get, we have to all go through accreditation. That means twice a year we go and we get all the updates of the law. What has the consultant done that allows them to really know what they're doing? And they are allowed to charge all sorts of things that we aren't, and we wouldn't anyway, because it's they're not governed.
All right, so a couple more. Combat Craig asked, double happy face cowboy hat. I think you need to get that checked out right away. Hopefully there's a clinic down the road you can go and they can handle that. Thanks for coming on, Combat Craig. It's been a while since we've seen you. Let's see. I think we got 2. I'm about to get in trouble.
Yes, you are.
Okay, 2 more. Let's see. Robert, is a denial of an earlier effective date and an appeal something that can still be addressed?
Yes.
If you still have it on appeal.
If it's been appealed, right. So the problem is, a lot of times people will be granted, say they're granted 30% for something and they think it's higher. If they only appeal the rating and they don't appeal the effective date, they haven't carried on the appeal as to that. So remember, when you file appeal, you want to file for not only the rating but the effective date if you think that's in error.
All right.
Who's the last? The lucky last.
Let's see. Oops. I don't know. I get so worried. All right. All right. Well, I just got to pick one, I guess. This is Carol's favorite here. Carlos, I am rated 100% for PTSD and TBI. I've been awarded aid in attendance, but not SMCT for my residual migraines, seizures, tinnitus. Any suggestions?
Push it. SMCT is wonderful. That's around $9,000 a month. And they realized that people that have traumatic brain injury have all sorts of needs that most people don't. And this money allows you to have those looked into, people to help you with things that you need. So if you have a doctor, get that. There's a form for, I think there's a form for SMCT.
I think you're right.
You want to get that form, and you want your doctor to fill it out to show all of the problems you have because of the traumatic brain injury. That's a great case. It's relatively new, SMCT, and there's so many veterans out there that deserve that, and they don't even know it exists. So go for it.
I would also say this is a frustration we've had in our practice, and something that's been really hard legally to disentangle. But a lot of times what we see are vets who are 100% for PTSD/TBI. That's not valid. Those are two different issues. It's kind of what someone said about chronic fatigue and what's it called? Fibromyalgia. Those are two different issues that both should be rated separately. And why is that important? Because, well, first of all, if you just by separately rating them, if you're 100% for both, you'll go from, if you have aid in attendance right now, you'll go from what's SMCL to SMCL and a half. Okay.
We're talking money.
We're talking money, yeah. But also, if we're showing, hey, you need aid in attendance for, do you need aid in attendance for both? You know, people with PTSD a lot of times will forget what they're doing. They'll wander outside. They'll
forget their doctor's appointments.
They'll forget basic things. If you need aid in attendance for both, then boom, that goes up to another, I don't know if it's O or M, but it's a lot more money.
A lot more money.
But the more you break it out and the more you show how much this affects your daily life, whom you need to take care of you, what skills do they need, what are you lacking, that gets you closer. Because as Carol said, I mean, it's a complete game changer. You know, 100% is $3,200 right now, and SMCT is coming close to $10,000 a month. So
right.
If you're in that realm, if if they're admitting that you're 100% for anything that says TBI, you know, even if they throw it for PTSD, that's really important to keep on fighting for that.
And another thing you brought up, if you get aid in attendance, you can get a really high rating if you get two aid in attendance, one for the service-connected physical problems and one for the service-connected mental problems. Or say you have a terrible problem with your hands, and that allows you aid in attendance just because you can't use your hands, and you have a problem with your feet, and that allows you aid in attendance because of that. That's going to give you a very high SMC. So those are things to think about when you think about what am I service connected for, and which one does each of these problems I'm connected for, how does that affect me? Something to think about.
All right. Well, thank you all so much for joining us today. We're so glad you could hear us today. And we want to thank Efrain over here who he got really upset
with us. We love
with
techie people.
He got really upset with us for the whole we can just do it ourselves thing is what we told him last week. And
yeah,
really
that didn't work out too well.
So thank you all, and we hope you guys have a great week, and we look forward to talking to you again next week.